Hello and welcome to this presentation of the 2015 BIA guidelines being presented by California Indian Legal Services. My name is Delia Parr. I'm the Directing Attorney of California Indian Legal Services Eureka office and very happy to be able to provide this presentation to you today. So the Indian Child Welfare Act was passed by Congress in 1978 and has never been amended. The Bureau of Indian Affairs first published guidelines for the Act in 1979, and at that point declined to publish comprehensive federal regulations, instead opting to publish at that point very limited regulations, mostly having to do with the notice requirements. This last year, 2015, the BIA did publish draft comprehensive regulations for the first time. They received lots of comments on those, and we're hoping to see final regulations from the BIA this year, 2016. In 2006, California legislature passed Senate Bill 678, which is now known as Cal-ICWA, and that incorporated or codified into state law the Indian Child Welfare Act and many provisions of the 1979 guidelines. And by doing this, California provided heightened standards for the Act in some areas. On February 25th of 2015, the BIA published updated guidelines. And what you'll see as we get through the presentation today is that the guidelines, the 2015 guidelines, are in many ways consistent with existing state law. And we're actually really going to focus in on those provisions that are consistent with or that are complementary to existing state law, because those are really the provisions of the guidelines that will be useful to you in your practice today. So the 2015 guidelines supersede and replace the 1979 guidelines. So we're not going to be looking at the 1979 guidelines at all anymore. We are just going to be relying on those 2015 guidelines. One of the really nice provisions of the updated guidelines are that they apply not only to state courts, but also, importantly, to placing agencies. And this is really critical because for so long there have been questions around whether or not the Indian Child Welfare Act applied in the pre-removal stage of a case. And of course, tribes have taken the position always that the Indian Child Welfare Act absolutely applies and that active efforts have to be provided at a very early moment to prevent the breakup. But this has not always been the position of counties, and we will talk about this more as we get through this presentation. But just keep in mind that as we go through, all provisions of these guidelines now apply not just to the courts, but also to the placing agencies, to the social workers. And the guidelines, the 2015 guidelines, are effective immediately. They were effective on the date that they were published back in February of 2015. So the 2015 guidelines, just like the 1979 guidelines, clarify the minimum federal standards laid out for us by Congress in 1978. And they are intended to increase compliance not only with the language of the Act, but also with the intent or the spirit of the Act. And they really focus in on the early intervention piece, so again, that pre-removal stage of a case, and also tribal jurisdiction. So we're going to go ahead and jump into the meat of the guidelines at this point. And I want to let you know that the way this presentation has been designed is that it follows the guidelines along sequentially. So if you have a copy of the 2015 guidelines in front of you, you should be able to follow along pretty easily. You will see that there are some provisions like active efforts that appear multiple times, and as a result we will cover them multiple times in the presentation. So talking about active efforts for the first time, we know that this is an issue that has caused a great deal of confusion and thereby contention between tribes and counties. The term itself, active efforts, has had varying interpretations, and because it is to be applied on a case-by-case basis, there's no black line rule for what constitutes active efforts. And these updated guidelines attempt to provide some clarity in this area. And they do actually specifically list out 15 examples of what active efforts would be, so I encourage you to go and take a look at the list. But really importantly for our purposes, the guidelines clarify for us that active efforts are more than and separate from the reasonable efforts required by Title IV-E. So they require two separate findings. And we're going to talk again about active efforts and when they apply to a case a little bit later in the presentation, so stay tuned for that. Okay, when does ICWA apply? Well, the updated guidelines clarify for us that the Act applies even during that pre-removal stage of the investigation, that it applies from the very earliest moment that a child comes into care. And specifically that it applies even in proceedings where the child is not removed. So it applies to investigations and differential response and alternate response. And it specifies that tribes can intervene in the pre-removal stage of a case to assist in preventing the breakup of the family. So really going to that provision of the Act that requires active efforts to be provided pre-removal. So the guidelines provide us with some additional clarity around when the Act applies. And they say, where agencies and state courts have reason to know that a child is an Indian child, they must treat that child as an Indian child unless and until it is determined that the child is not an Indian child. So where the agency receives a referral of a suspected abuse or neglect and they have information that the child is receiving health services from Indian Health, or that the child is a biological child of a tribal member or something along those lines, that should automatically trigger the Act and that the tribe should be noticed and active efforts should be provided to prevent the breakup of that family. This provision is absolutely consistent with the existing California rules of court. Okay, marching along the guidelines, we come to section A4, how to contact a tribe under the guidelines. And this is a new section. This is not a section that was found in the 1979 guidelines. And we really think that the intention here is twofold. One is to really reinforce the notice requirements that are found in the Act itself, but also really to encourage informal and very fast notice to tribes. That would include things like email or fax or a phone call, so that tribes have an opportunity to intervene and exercise concurrent jurisdiction or take exclusive jurisdiction at that earliest possible moment. So what we have here is a requirement still to notify the representative that's designated in the BIA list of tribal agents for service of notice, for service of ICWA notice, that list that's published in the Federal Register, but also to contact the BIA where there's not accurate contact information for tribes, or where the tribe has failed to respond to written inquiries. And in that case, the intention is that perhaps the Bureau has better contact information or can provide additional guidance. So the updated guidelines provide clarity for us that the existing Indian family exception is not valid. The existing Indian family exception was a judicially created doctrine that caused a lot of problems here in California, but has not been a problem since the passage of 678 in 2006, at least here in California. But it's really helpful that the guidelines do specifically state that it is not valid. So hopefully this is the last time we have to deal with this. Okay, section B1. When does the requirement for active efforts kick in? Well, this particular section is one of my personal favorites because it tells us that active efforts should begin at the moment the possibility arises that an Indian child may be removed. At the moment the possibility arises that an Indian child may be removed. Now this is really critical because tribes have expressed frustration for a very long time that what happens is that families get involved with the system And what I mean by that are the referrals of abuse or neglect are received by the agency and investigations are conducted, but that no active effort service plan is put in place. And as a result of that, the family deteriorates over time, that the parent's behavior continues to worsen until such a time that the children are removed from the home. Now, under the new guidelines, once it's known that that referral involves an Indian child and an investigation is happening, active effort services should be put in place. And here in California, active efforts are supposed to utilize the available resources of the child's tribe and should be culturally appropriate. So at that very early stage of a case, the agency should be working together with the tribe in a concurrent fashion, because this is the stage of the case where neither the tribe nor the county or the state court have obtained a valid initial jurisdiction. So both at that point have concurrent jurisdiction, and if they work together and provide services that are of benefit, then the hope is that we can see more families stay together. The other nice thing that this section does is that it clarifies that active efforts must be conducted even while the agency is investigating whether the child is an Indian child. That's really helpful, particularly in California, where there are a number of different tribes, oftentimes in a small geographic area, and it's difficult to determine whether or not the child is eligible for enrollment in X tribe versus Y tribe. Their enrollment questions can be complicated in that active effort services should not wait for that process. That in and of itself can create a situation where that child needs to be removed eventually, and that is really, again, one of the primary focuses of these guidelines is that early intervention piece and making sure that families are getting active efforts and that tribes and counties are working together in a really strong concurrent way at that stage of the case. For the next several slides, we're going to be talking about inquiry and membership and notice. And these are really the most important provisions of the Act, because the rest of the Act doesn't apply if proper inquiry is not done or if notice is not provided. So let's get started. What is new about the 2015 guidelines with regard to inquiry is that the standard has changed from reason to know to reason to believe. So at section B2 sub A, you'll see that it says agencies, courts must ask whether there is a reason to believe a child that is subject to a child custody proceeding is an Indian child. So really trying to make sure that Indian children are identified so that the rest of the Act is applied. You'll also see down at sub B2 that the court must confirm that the agency used active efforts to work with all tribes of which the child may be a member to verify membership. And it's always been the case that the agency was supposed to provide notice to tribes, but this is the first time that we see this active efforts requirement being used, which should be helpful. So we're now going to turn to section B3 and talk about membership in a tribe. I think we're all familiar with the fact that tribal membership determinations are left exclusively to the tribe, and that's really backed by federal law. That's very definitive. And that for ICWA purposes, formal enrollment in a tribe is not required. That membership in a tribe is sufficient, and again, it is the determination of the tribe as to whether or not a person qualifies for membership in that particular tribe. The guidelines also provide clarity around the fact that the state cannot substitute its judgment for a tribe. So, for instance, it would be inappropriate for a state court to review a tribe's enrollment ordinance to determine whether or not a child is eligible for membership in that particular tribe, because going back up to bullet point 1, tribal membership determinations are left exclusively to the tribe. And this is a change with the new guidelines. The BIA can no longer provide membership determinations. So it used to be that an agency could contact the Bureau and get information about tribal membership. That is no longer the case because, again, going back up, tribal membership determinations are left exclusively to the tribe. So turning now to section B4, we're going to continue talking about membership in a tribe. And where the child is eligible for membership in more than one tribe, the guidelines specify that the agency should notify all of the tribes, specifying the other tribes that the child may be eligible for membership in. And then the agency should step back for a second and give the tribes the opportunity to make the membership determination on their own. So for instance, if a child is eligible for enrollment in Hoopa and Big Lagoon and also Yurok, the three tribes should be able to, amongst themselves, try to figure out which is the appropriate tribe to intervene for ICWA purposes before the state court comes in to make a determination. And where the determination can't be made by the tribes, then the court should look at significant contacts. So things like the preference of the parents, the length of domicile or residence on or near the reservation, tribal membership of the custodial parent or Indian custodian, and the interest asserted by each tribe in response to the ICWA notice. And based on that, the state court should then determine which tribe is the most appropriate tribe to intervene in that particular case. That does not establish membership in that tribe. That would still be subject to the tribe's membership criteria as laid out in tribal law. This is really just for the state court child welfare process, which tribe will participate or intervene. Continuing on with membership, the guidelines provide that the agency should take steps necessary to obtain membership for the child in the tribe that is designated as the Indian child's tribe. And this is really important because oftentimes in these cases, the agency is the only entity that has access to the information necessary for the enrollment. Tribes often require original birth certificates for not only the child but also the biological parents, and if the biological parents weren't enrolled for some reason, it may require birth certificates for the grandparents or death certificates, a variety of documentation to establish membership pursuant to tribal law. And that if the parents are not able to obtain that information because the very nature of a dependency case means that parents are struggling and not able to provide appropriate care, the agency standing in the shoes as the responsible entity for the child would be most appropriate to help with the enrollment at the request of the tribe, I would say. And this is really consistent with the California rules of court that are cited here. But I need to highlight for you that this is a case that's currently before the California Supreme Court, because what the California rules of court say that is different than what the 2015 BIA guidelines say here on the slide is that the agency has to make active efforts to try to enroll the child. And this is in conflict with a strict reading of the law because, specifically for the Abigail A situation, Abigail was not a member of her tribe, and neither of her biological parents were members of the tribe. And as we all know, in order to be considered an Indian child and be provided the protections of the Indian Child Welfare Act, the child has to either be a member or be eligible for membership with a parent, a biological parent who is a member. And Abigail did not meet that definition. Again, she is a child that herself was not a member and did not have a biological parent that was a member. But the facts of her particular case are really interesting because her tribe relies on lineal descendancy, meaning that if in order for her to be eligible for membership, her biological parents did not necessarily need to be eligible for membership. She just needed to be able to trace her lineage back to a lineal descendant who was a member. And her tribe had actually provided information to the agency and the court documenting that she was indeed eligible for membership, and really all the agency had to do was get a birth certificate, or maybe 2 birth certificates, I can't recall, and a death certificate, and essentially sign and date the form that the tribe had provided to the agency, already completed, to basically start her enrollment application with the tribe. And the county didn't want to do that for whatever reason. So, this case again is currently before the California Supreme Court. This is also a case that we have done a fairly short webinar on, that will be posted very similarly to this webinar, so that if people are interested in understanding the facts of that case in a more detailed way, that they can go and listen to that, and hopefully that will help in understanding whatever decision we get from the California Supreme Court. That case is set to be heard by the California Supreme Court in April of 2016, so we would anticipate getting a decision probably sometime over the summer, and certainly we hope to get one by the fall. So keep your fingers crossed on that. So this is the slide that goes along with that California Supreme Court case in Re Abigail A. And again, the question that has really been presented to the Cal Supreme Court is, does the agency have an obligation to assist in enrolling children in their tribe when they don't yet meet the technical definition of an Indian child because a parent is not yet enrolled? And, given the clarification of the BIA guidelines, we really hope that the California Supreme Court comes down and says, yes, that the agency does have an obligation to assist in enrolling children, but that perhaps that obligation is not an active efforts responsibility. And again, there is a separate webinar on this topic, so we're not going to belabor the point here, but just again, the agency is the only entity with the authority to obtain the necessary documentation for enrollment. And under what's something called the California Foster Care Bill of Rights, the agency should be assisting with enrollment, since there are benefits that flow from that enrollment. And those are, of course, both tangible and intangible benefits. And, I can't stress enough the importance of having an agency be able to assist with this, because without having the agency involved, it may preclude that child from being able to become a member, just given the way the state structure is around being able to access documents from the state of California. So again, keep your eyes open for that. This is a nice clarification that the guidelines provide us. Tribes may authorize another tribe for ICWA purposes. And so what it specifically says is the Indian child's tribe may authorize another tribe to act as a representative for the tribe in a child custody case, including having a representative tribe perform home studies or expert witness services for the Indian child's tribe. And where this usually comes up, not exclusively, but where we have seen it most often, is where there is an out-of-state tribe that contacts a tribe local here in California because the child is located here, and really wants to be able to rely on a tribal determination of whether or not a home is an appropriate placement for that child, rather than having to rely on the counties. And there has been a lot of discussion around this somewhat recently in California, so the guidelines have been very helpful in this area. So I wanted to point this out to you. Notice, again, it's the inquiry, membership, and notice provisions that are really such an important piece of the Act, because you just can't proceed to the other provisions if you don't get these right. And notice is required for each proceeding, and as we talked about a little bit earlier, in addition to that formal notice that's required by the Act, these guidelines also really serve to encourage the agency, to provide guidance to the agency that they should be working with the tribe from the earliest possible moment, and that early notice can be informal in nature, but that the goal should be for notice to get to the tribe as early as possible, and for it to be as meaningful as possible, so include as much information as the agency had. And along those lines, the new notice requirements provide that notice should actually include a genogram for both parents. And if the child is transferred interstate, what the guidelines now say is that both states are required to provide notice. And so this is an area that for a long time we saw cases fall through the cracks, because each state would have assumed that the other state provided the notice, and now it's just very simple. Both states get to provide the notice, and hopefully that will alleviate all of the issues in that area. So if you're following along the guidelines with us, we're now at section B8. We're going to talk just very briefly about emergency removal, because this is a section that is different than what you'll find in the 1979 guidelines. So the updated guidelines provide that an emergency removal is allowable, but only is necessary to prevent imminent physical damage or harm to the child, that it requires a showing of active efforts, and that the temporary emergency custody should not be continued for more than 30 days unless there's a hearing noticed in accordance with the guidelines that's held and results in a determination by the court that's supported by clear and convincing evidence and the testimony of at least one qualified expert witness. Or, in the alternative, that extraordinary circumstances exist. And the reason that we put this in here is that we think it's something to point to when folks in court are giving time waivers and the case seems to really be dragging on, particularly where there is any concern at all that removal was inappropriate, that the time frames that are built in to state and federal law for these cases are there for a reason, that the goal is to provide services to a family at the earliest possible moment, and that includes not waiting to get to the dispositional stage of a case for months because of ongoing continuances, that if there's an emergency removal, this case should be before the court, and the court should be receiving adequate evidence to determine that the emergency removal was done to prevent the imminent physical damage or harm to the child, or that extraordinary circumstances exist. So hopefully this information is helpful. So we're now going to turn to section C2 and talk about transfers to tribal court. And I'm going to tell you at the outset that this section is a little different than this section looked in the 1979 guidelines, and that there are some components of the new guidelines that are in conflict with existing state law. But I wanted to share this information with you because there are some really valuable pieces of it that you can walk away using today, and I will highlight those for you. So to start with, just a little bit of background. I think that most of you are familiar with the fact that a state court must or shall transfer a case to tribal court unless certain good cause factors exist. And that the reason for that is that while a state court can assume valid initial jurisdiction over a case involving an Indian child, that jurisdiction is considered by case law to be referral jurisdiction, meaning that they get to hear the case assuming that the tribe doesn't ask to hear the case. And if the tribe does ask to hear the case, then the state court has to transfer it or make good cause findings. And so under the new guidelines, the state court has to transfer that case unless either parent objects, and that has been the case in California for a long time, that parental objection operates as a veto, or if the tribal court declines the transfer, which again is consistent with state law, or the state court determines that good cause exists to deny the transfer, and we'll talk about that a bit more. So in starting to consider the good cause question around transfer to tribal court, let's start with what a state court should not be considering when reviewing a transfer to tribal court request. A state court should not, under the new guidelines, be considering whether or not the case is at an advanced stage. And this is new. This is inconsistent with existing California law, and I really wanted to point that out to you. Under existing California law, a case being at an advanced stage is in itself good cause to deny the transfer, with the exception being that if the party requesting the transfer was waiting until reunification services had terminated, that was not to be considered good cause. But generally speaking, a party waiting until the case had progressed to an advanced stage was considered good cause to deny the transfer. So that is a direct conflict, and California law will control, but I would say that this is something that could still be utilized in argument, that we now have the federal government providing guidance to state courts around this issue, and that it is really clarifying that it does not believe that the advanced stage factor should be considered. So the court may also not consider the Indian child's contacts with the tribe or reservation. So again, this is really the BIA, in my opinion, coming down hard on the existing Indian family doctrine and making sure that it is not being utilized anymore, because it is not a valid doctrine. The state court should not be looking at whether or not the child has ever lived on the reservation or any of those things. The state court should also not be looking at the socioeconomic conditions or any perceived inadequacies of the tribal or BIA social services or judicial systems. So the state court should not be looking at how the tribal court is formed, or whether or not the tribal court is operating as a standalone court or is a component of tribal council or any of those things. The state court should also not be looking at a tribal court's prospective placement. A tribal court, when it receives the case, will review the documents before it, hear from all parties, and make a determination. And that is not something that the state court should be reviewing. And the burden of establishing good cause not to transfer is very solidly on the party opposing the transfer. So moving on now to section D, we're going to talk about involuntary proceedings. And you'll see there at D2 that it requires detailed documentation that active efforts were provided prior to removal or termination of parental rights. And that active effort should include the available resources of the tribe, extended family, and Indian caregivers. And this is really very consistent with existing California law. In all of the counties that I practice, we do have reports that detail what active efforts were provided. And if you look at the Welfare and Institutions Code, you will see that in California, active efforts are required to utilize the available resources of the tribe and the family. Still talking about involuntary proceedings, at D3, you'll see a discussion of the applicable standards of evidence or proof. And this is consistent with what we have been doing all along, that for foster care we're using clear and convincing evidence, including the testimony of a qualified expert witness. And for termination of parental rights, it's that higher standard of beyond a reasonable doubt, again including the testimony of a qualified expert witness. So no change here. Moving along to section D3, looking at subsection C, this has been clarified for us that you have to be looking for a causal relationship between the existence of a particular condition in the home that's likely to result in serious emotional or physical damage to the child. And that's really social worker practice, but this was not as clear previously in the 1979 guidelines. And the the next section here that says the following on their own do not constitute clear and convincing evidence: isolation, single parenthood, custodian age, crowded or inadequate housing, substance abuse, or non-conforming social behavior. And what we think the Bureau of Indian Affairs was going for here is that, the intention behind the Indian Child Welfare Act was to ensure that Indian children were not being removed from their home because of tribal standards, because of a misunderstanding of tribal standards. But that we have seen so far that this particular provision of the guidelines has been a bit problematic, at least here in California, because of that inclusion of substance abuse. That tribes that I work with, have some concern where small children are in a home where the parents are abusing substances, and that we've had departments argue that there's no causal relationship between substance abuse in the home and a likely result in the serious emotional or physical damage to the child. And, I think that those are very factual questions, but I just wanted to point that out to you so that we are all understanding at least what the guidelines are telling us, so that we can utilize them to make sure that we're looking out for the best interest of the kiddos out there. At D4, we get to qualified expert witness. And this is a section in particular that's so helpful here in California. We know that the qualified expert witness should have knowledge of the particular tribe's culture and customs. That's consistent with existing state law. But what is different here is that you'll see at section D4B that the qualified expert witness list starts out by saying that it's a preferential order. And if you look at the California Welfare and Institutions Code regarding qualified expert witnesses, what you will see is a list that looks similar to this list, but it does not specify that it's a hierarchy. And although I would argue that anybody that is operating based on common sense would be able to determine that it is indeed a hierarchy, because it does not explicitly state that it is, and other provisions in the Welfare and Institutions Code do explicitly state that they are hierarchies, that it has been held to not be a hierarchy by a number of different trial courts, although I'm not aware of an appellate court decision on point. Having the BIA guidelines come in and provide us with a preferential order hopefully will alleviate the contest in this area. That has been the experience in my practice so far. So given that discussion, what an agency or state court should be looking at with regard to determining the most appropriate expert is there a member of the child's tribe that's recognized by that tribal community as knowledgeable in tribal customs as they pertain to familial organization and child rearing practices? Number 2 on that list is a member of another tribe recognized by the child's tribe as a qualified expert witness. And then we move down to a lay person who's recognized by the child's tribe as having those same qualifications, being knowledgeable in the tribal customs as they pertain to the family organization, etc. And then the 4th on that list is a professional person having substantial education and experience in the area of his or her specialty. So clearly it's a hierarchy. Again, it's nice that the BIA laid out for us that it really is a hierarchy, as silly as that argument has always been to me. So now we're at section F1, talking about placement preferences. The agency or the court must follow the placement preferences that are laid out in the Act. And where that cannot be done, the agency must demonstrate by clear and convincing evidence that a diligent search was made to locate the ICWA compliant placement. And our take on this is that it's very consistent with the California Welfare and Institutions Code, that if you look at section 361.31 sub K, you'll see that here in California we already have an active efforts requirement for the agency to comply with the placement preferences to try to locate a home that falls within the placement preferences, and that they have to maintain documentation of their efforts and make that documentation available to tribes if tribes ask for it. So looking at section F1 sub D, we will see that the good cause finding to deviate from ICWA's placement preferences is required by the court prior to the actual departure from the placement preferences. So two really important factors there. One is that the good cause finding is required by the court. So a social worker or the agency cannot be making that good cause finding. They have to get it before a court. And the second thing that's important there is that that good cause finding is required prior to departing from the placement preference. So not after, before. So just to clarify that, I'm going to provide a little bit of background. So often what happens is that a tribe finds out that a tribal member child has been placed outside of the placement preferences and gets the matter before the court and has a whole hearing on trying to change placement. The reality of that situation is that that placement that is outside of ICWA's placement preferences should never have occurred without the court having made the finding. That case should have been back before the court before that ICWA non-compliant placement was made, and a judge should have signed off on it after reviewing the facts of the case and determining whether or not good cause existed to deviate from the placement preferences. And we will talk in just a second about what good cause can look like under the 2015 guidelines. At first, I just want to mention that the burden to establish good cause is on the party seeking the departure. So if the agency wants to place outside of the placement preferences, the agency should be getting the matter before the court and has the burden of establishing to the court that there's good cause to deviate from the placement preferences. So hopefully everybody understands that. The three important things on that side are that the good cause finding has to be made by the court, not by a social worker or the agency, that good cause finding should be made prior to the placement preference that is outside of ICWA's requirements, and three, that the agency would have the burden of establishing that good cause exists. So, what can good cause be based on? The court can look to the request of the parent, the request of the child, or the extraordinary physical or emotional needs of the child. And this is consistent with the 1979 guidelines, but I really want to highlight it for you because it's something that is misapplied regularly. If a court is going to make a good cause finding to deviate from ICWA's placement preferences on the basis that the child has an extraordinary physical or emotional need, that fact and that child's needs have to be established by a qualified expert witness. That cannot simply be argued. That has to be established by a qualified expert witness. And good cause, according to the new guidelines, cannot include ordinary bonding or attachment that occurs in a non-ICWA compliant placement. And that particular component of the guidelines is very much consistent with existing case law on point. And importantly, good cause does not include independent consideration of best interest because the preferences, ICWA's placement preferences, reflect the best interest of an Indian child in light of the purpose of the Act. What this is saying is that a state court judge should not be having a contested hearing around best interest with regard to placement. That a state court should be looking at those factors that are clearly laid out in F4 sub C, the request of the parent, the request of the child, or the extraordinary physical or emotional needs of the child as established by a qualified expert witness. And the state court should not be conducting a best interest analysis because according to the guidelines anyway, the Indian Child Welfare Act included the placement preferences after Congress made a determination about the best interest of Indian children. And that because Congress had already made that determination, that it's inappropriate for the state court to be conducting that analysis. So that's a biggie, and we will see what that looks like in the BIA regulations when the final is issued sometime this year. Continuing along with the placement preferences, in making the good cause determination, a court may not consider the socioeconomic status of any placement relative to another placement. And I think that we all know the reason for this is that we end up in contested hearings where the issue really is whether or not the child is better off with a wealthy family attending a private school versus living on the reservation and attending the public school. And that is an inappropriate analysis to be applying in these cases. And we have reached the last slide in our presentation here, invalidation. And invalidation under the new guidelines is very consistent with what the Indian Child Welfare Act provides for us, and also what the 1979 guidelines have to say about it. And that is that an Indian child, a parent, or a tribe may petition to invalidate any action that includes a violation of sections 1911, 1912, or 1913 of the Act. But we wanted to point this out because it is a provision that is not used very often, but would be very simple to use. In order to request an invalidation of a case, one need not go to the appellate court. A petition for invalidation can be filed at the trial court level. So for instance, if you are in a case and you have a violation of the notice requirements or the active efforts requirements, any of those violations that would be found in sections 1911, 1912, or 1913 of the Act, you could file a petition to invalidate and ask that that be put on the calendar of, for instance, the presiding judge of the juvenile court or another judge, since you probably don't want that heard by the judge that made the bad ruling to begin with. But that's an option that exists. Invalidation is a neat tool because it takes the case back to the point at which the violation occurred. So, if it's a notice issue, then it would theoretically take it back to, could theoretically take it back anyway to the beginning of the case. We have seen situations where we have been able to add on time for a parent's reunification services by arguing that active efforts weren't provided, so that a parent doesn't time out. Those are all really neat tools to have in these cases. I wanted to make sure that we shared that information. The last point that we want to make here today is that any party may challenge a violation of any other party's rights. And a party whose rights are violated is not required to bring such a challenge themselves. So, an example of this would be where the tribe is not present in a case because the tribe didn't get notice of the case, and a parent raises that issue. It is proper for the parent to raise that issue on behalf of the tribe. And I think that the rationale behind that is really obvious. It's that the tribe didn't have notice, and the tribe may still not have notice because either inquiry wasn't done or notice wasn't provided, one of those two things. And the other reason that we think that this particular provision exists is that the reality is that often dependency panel attorneys are not well versed in the ICWA. So it may be true that it's the tribe that's arguing that active efforts weren't provided to a parent or child, even though, of course, the parent and the child are represented by counsel in the courtroom. So this is there to help clarify that particular issue, and hopefully you don't run into that in your practice. Thank you for joining us for this presentation today. We really hope that we have provided you with information that you are able to walk away and utilize right away. If you have questions, you are welcome to email me. My email address is there on the screen. We also have additional educational materials located on our website at www.calindian.org. Thanks again.